Hello, and welcome to the Arbitration Conversation. The Arbitration Conversation, pretty soon we're going to be to 100 episodes. So we're excited as we continue to interview really interesting top-level, biggest leading experts in arbitration in the world. And today we have Tunde Ogunseitan. And Tunde, he is dual qualified in Nigeria and the UK, and he has done arbitrations, mediations, been of counsel, worked with the International Chamber of Commerce of Counsel as well, and he is an absolute gem of a person and also an expert in arbitration and problem solving. So before we begin, I just wanted to right away thank you so much for staying up late there in London to be interviewed today. So thank you, Tunde. This is going to be fun.
Yeah, it is my pleasure to be here, Amy.
So I guess I want to start off with just kind of asking you your journey of getting into arbitration. Before we started taping, for those listening, we just started talking about, all these exciting areas of dispute resolution that you've been part of. So if you wouldn't mind sharing a little bit about your journey and what brought you to arbitration and mediation.
I always wanted to do maritime law, and I didn't appreciate how much that formed the backbone of arbitration. And so when I started out my career as a maritime lawyer in the city, the first major cases I worked on as a junior lawyer were two oil rigs that had been leased, and that was an arbitration. And it was a very interesting case, but I then switched back to litigation, which I thought gave me good grounding, but you could never really get away from arbitration working for the big firms in London, because in those days, we did big litigation cases and we did arbitration as something else for the clients, but gradually, arbitration then began to interest me to learn about it, especially as I started working on the cases in the city. My draw to arbitration finally sort of codiciled when I went into the ICC as counsel for the common law regions there. That was an eye-opener and a full immersion into the world of arbitration, which I'm still in, and I find it very interesting, exciting, as a useful mechanism that floats above all the traditional core dispute resolution systems around the world.
And especially as a problem-solving mechanism, maybe you want to speak to that.
Yeah. One thing I like about arbitration is it has been as old as humanity itself. If I think about it, I was asked once at the African Union that arbitration is an invention of Western nations, and I said, no, that's not true. I gave the example that in my culture, when there were disputes, because there were business and trade disputes, the elders would come out and they would make a decision, and that decision would have to be enforced. Now, in those days, if you think about it, the price usually was a cow, a chicken, a goat, and they would go into your field, take one cow, go to the chicken, and put it in another man's field. Simple enforcement. That is it. So what's the difference between the arbitration? The only difference I can see is parchment and the ability to move the winnings of an arbitration, in the sense that the parchment allows you to move it, but you can also move a cow and a chicken and transport it and trade it.
But you're really on to, I just want to reflect a moment, because this is really important. If you look at the history of arbitration, I mean, there's ancient Egyptian arbitrations, right? And if you think about this, I love this, thinking about the elders coming out and making a decision because you trust them, right? And they know the norms of the community.
Indeed.
And really, it's kind of the same thing of what you're explaining.
That's what arbitration is. Parties, through their own free will, and it's important here to talk about the free will and the contractual nature of that free will, have gone to an expert who they trust to resolve the dispute, because they trust that the expert understands the very nature of their problem. That is what arbitration is. That is why it's developed and even splintered. Before, you used to have the maritime lawyers who were perennial arbitrators, the insurance not so much, but then you had the maritime lawyers and you had the commercial lawyers who did sort of commodities, and it wasn't strict maritime. And that has evolved into where construction lawyers are now big on arbitration and have embraced other experts, the DABs, to solve their disputes. And even gas pricing are also, involving experts. I asked somebody what the difference between a gas pricing dispute and an expert determination is. And that debate is still ongoing between us. So the expertise and the trust in the expertise is what,
especially in these areas. So, it's important to note, like, we are talking about these kind of commercial areas, business to business type areas, as opposed to consumer and employment. But I think it's especially in these areas, as you talk about. Absolutely, maritime construction, which is what I practiced. These are areas, I love this discussion. It really creates this culture of trust around arbitration as a problem-solving mechanism.
And it's mostly business to business. In the UK, the amount of small arbitration, and in Nigeria as well, people always assume that arbitration is restricted to the big institutions because those cases, for example, make the headlines. The amount of high-value ad hoc arbitrations that go on around the world on a daily basis is astonishing. The big ticket items make the news if they're from one institution or the other: ICSID, LCIA, ICC, but there's also quite a lot of state-to-state arbitration, which is ad hoc in many ways. They call it something else. Experts still make those decisions. And there is still at least some, a high number of commercial decisions made in ad hoc arbitration, which are not institutional. So the effectiveness of it as a dispute solving mechanism is here to stay, and I don't think somebody else has come up with another way to resolve.
Well, and especially, as you're talking about sort of the court systems, right? And often when we think about dispute system design, and you were saying how arbitration really is an excellent mechanism for these areas, especially when you're talking about where you need the expertise of the arbitrator to be on point, not maybe a generalist judge or a judge who might not understand the subject matter, or a jury that might not understand the subject matter. And so when we think about a comparison, right, we want to sort of compare arbitration to the competition, which in a lot of ways is the courts. So when you think about that, does that make a difference when you think about where arbitration stands as a problem-solving mechanism in comparison to litigation, for example?
If you go to a court, you're going to get a judge. If you're lucky, that judge will have some experience in that area, general area of law, as opposed to a position where you want someone who has regulatory experience in a particular type of radio waves when you talk about specific computer applications, and the dispute is about the technicalities of that system. Well, you could do it two ways. You could either get a commercial arbitrator and he gets an expert in. But increasingly, we're finding that there are lawyers who have that kind of expertise, technical lawyers, engineers who became lawyers, doctors who became lawyers, especially in the pharmaceutical side and biotech. When these kind of disputes, you need someone in that industry who can speak the lingo, so to speak, and understand the interfaces of the parties' disputes. Now, I've had the privilege of reading awards by lawyers and awards by experts. They're quite different. And when you see a non-lawyer render an award, it's substantially different than if you see a lawyer render an award. And one has to appreciate the nuances. Now, that does not mean that that's the right approach all the time, but there is a scope for expert arbitrators to determine certain types of disputes in certain types of industry.
Well, one argument, however, when it comes to arbitration as a problem-solving mechanism versus litigation, is the cost. These expert arbitrators can be very expensive per hour, and you don't pay a judge per hour. You just pay your filing fee. How does that play into the analysis?
I think the cost of most arbitrators are negligible, and that's backed up by data, at least internal ICC data that we used to see, because in most of the cases, you could see what the lawyers were charging because they had to recoup their costs, and you could see what the arbitrators were charging, and what the institutions were either paying, or even sometimes when an award comes to be challenged, you can see the difference between what they paid the arbitrators and what the costs on the lawyer side were in any arbitration. So I don't think the cost of it, when you look at the arbitrators themselves, are the big issue here. There are other surrounding costs which must be taken account, but their costs are not, because you say that the court infrastructure is not paid for, the rooms and that's it. But really, at least the substantial part of that cost is still counsel costs, which will be the same whether you are in court
or more, right? Because in litigation, you have more time, more discovery, more of the different aspects that can make your attorney's fees actually higher in litigation than arbitration.
I agree with that. But there's one more factor, I think. Whether ad hoc or institutional arbitration, I think the fees are kept relatively modest by the institutions through their, whether they operate an ad valorem system or an hourly rate system. The institutions do a terrific job, at least my experience, in keeping the fees low. One of the constant fights between arbitrator and institution, and I don't think I'm giving anything away, is that you're going to pay us more, institutions, and we can't pay you more because the parties will think that's unfair, and the parties also haranguing the institution, so I think we're paying too much, and it's like, no, actually you're not paying enough, and we keep and the institutions are usually the arbiters in this dispute, trying to keep the costs low, and you see that when they're monitoring proceedings and saying, look, we don't think you can really have another hearing here, or when it's not. I'm not talking about stopping arbitrators from having hearings, but can't you do this by video conference? This is just a procedural hearing. And that's some of the guidance that you give to arbitrators, saying,
Well, and as an arbitrator, you have incentive to keep the costs low and to be reasonable and to be efficient, because no one's going to select you if you get a reputation for high fees and, and not being efficient. So I would think that arbitrators certainly have incentive as well to be efficient and to use their time wisely.
They do, but again, it's an interesting balance if a party wants to drag you all the way from Singapore
right.
To Egypt to come and have a procedural hearing, and they think it's unfair if they don't have their procedural hearing in person. But you know that if it's an arbitration seated in Egypt, you have to be mindful that this arbitration might be enforced later, and somebody says it's procedurally unfair for me to do a video conference when you don't really see the need to fly all the way and incur the cost. But there are also different things that add to the cost of arbitration. It's become more sophisticated by its very nature. It is as complex as any litigation. What really adds to the cost when the parties look at it, it's sometimes you're dealing with 2 or 3 cultures. There's a lot of translators, people flying in, experts flying in. And so when the parties look at the cost of arbitration, the real cost they are complaining about are maybe the cost of the room and the fact that they have to pay a private judge. But when you look at those line items in the whole cost of an arbitration, they're minuscule.
Yeah, well, and the other point, time is money, right? And so, when you think about delays in the courts and how that factors in, that can be helpful to some respondents, right? Because they want to delay it as long as humanly possible, but it can be harmful as well when you have to wait, especially if you are a business in construction. I know we always really needed to get a fast resolution, because especially if you're in the middle of a project and you need to continue working together and you need to finish that project.
That is when the selection of the process matters. Arbitration is when the parties really have reached the end. If you look at construction disputes, before you get as a conflict management and avoidance mechanism, they usually have the dispute boards, and the DABs to deal with those issues where you have the engineer come in. And so that's why drafting your arbitration clause and understanding that even a multi-tiered arbitration system with different dispute resolution mechanisms inserted in there can save you money. You don't take every problem to arbitration where you should be able to look at the problem saying, where will an expert do here? Where will, if it's a construction process, what we need is an engineer to make a decision so this process can go to an end. And if we have a problem with all of it at the end, we'll kind of discuss it with arbitration. But in type of construction process where certain things cause delay and need to be resolved, the right process there is to put a dispute management system in.
Right.
Doesn't break the relationship, because arbitration in many ways breaks the relationships of the parties, and sometimes that's not the right mechanism to use.
Right. Well, and certainly it's absolutely, I agree, having a proper, thinking about conflict management from the very beginning and having a process in place, which might be a stepped process, might be mixed mode, allowing for a process, I think, is very important to again, it goes back to the theme of today's discussion, which is problem solving and creating a conflict management process to solve the problems, right?
But I want to go back just a little bit, it's process and time. If you have the right process, you will save time. If the process is wrong and you haven't anticipated what kind of dispute you're going to have, then the process if you've not thought about it even before the dispute starts, then you might end up with a design of a process which is wrong for that project. So it's very important for people when they're doing their project prep to think through the processes. Like, if we do come up with this, it's just not copy and paste. How are we going to solve each problem as we go along, and what mechanism are we going to use? Do you have the appropriate mechanisms? You can always agree later, of course, after the event. But when parties are divorcing, nobody sees eye to eye, then that's the problem. So agreeing.
Exactly. Yeah, I agree.
After the event becomes another issue. So it's important to design the right process so you can achieve the time saving you want when that process is used. If you use the wrong process to solve the wrong problem, all you will get is cost, delay, and pain.
Absolutely. Well, that's a perfect thing to end on, because that is absolutely correct. I fully agree with that. Listen, Tunde, I got to say thank you for taking time. Thank you for staying up late there in London, and really good stuff talking about arbitration as a problem-solving mechanism. Thank you dearly for your time.
No, it's my pleasure, Amy.